The speaker of the day, Ms. N.S. Nappinai, Supreme Court advocate and founder, Cyber Saathi, with about 29 years of experience, specializing in constitutional, criminal, IPR, and cyber laws. She is amicus curiae in Prajwala versus Union of India to formulate the methodologies to remove child sexual abuse material and violent videos of offences against women from online platforms. She represents various states before the Supreme Court of India on cybercrime-related matters. Ms. Nappinai is part of government committees dealing with various policy issues on cyber law. She has contributed extensively to the drafting of India's Commercial Courts Act 2015. Ms. Nappinai has presented before the Lok Sabha Parliamentary Committee, National Cybersecurity Center, many other government committees as expert on cyber safety online, IT Act, cryptocurrencies, and blockchains. Nappinai was an expert member, Tamil Nadu, for formulating the cybersecurity aspects under the state policy. An alumna of Stanford Center of Democracy, Development and Rule of Law, Sheving UK, IDLP USA, Nappinai trains judges, police, armed forces, and intelligence agencies at national and state academies and regularly addresses sessions at various national and international conferences. She is a TEDx speaker, is a prolific writer who has authored various publications to her credit and has authored the seminal book on cyber laws titled Technology Laws Decoded. Her book on cyber safety and emerging technologies is forthcoming in 2020. Thank you so much, ma'am, for addressing us, and I'm sure it's going to be such a learning experience today. Over to you.
Thank you, Jayalakshmi, for that lovely introduction. And I would like to start off by saying I'm actually doing two of my favorite things today. You know, the first is like my homecoming. I am here with my alma mater, the Madras Bar Association, and with all of you, my friends. So that itself is a treat. And the added bonus for me is that I am speaking about a topic which was my first love, my first passion for law. You know, I always tell people that I decided to study law when I was in my 7th standard. And the reason I studied law was to practice criminal law. So that's like my ultimate passion amongst all the fields of law that I have, dabbled in, I would say. So to just set the pace for today, I would like to just walk you all through what is it that you're going to be able, or rather I would say I will be sharing with you all today. So the roadmap for today, I think this picture is one of my favorites when I want to talk about cyber crimes and enforcement. And in this, if you see, I always say that these round wheels here are technology and these square wheels are law. And this poor man trying to move uphill with his cart on square wheels is the judicial system, you know, the law enforcement and judicial system, which is struggling on square wheels to deal with something which is on super fast lanes. So when we talk about the roadmap for today, the first thing I want to assure all of you all is...
Ma'am, I'm sorry to interrupt, ma'am. Just a minute, ma'am. Ma'am, can you make the presentation full screen, ma'am, so that it will come...
Is it better now?
Yes, ma'am.
Okay.
And ma'am, I would also welcome honorable judges who have joined for the meeting today and senior advocates also, ma'am. Thank you very much, ma'am.
Sorry for it. Oh, not at all. Just to reiterate what I had mentioned earlier, though I do have a 150 slide presentation and I want to walk you all through a lot of things I want to share today, please feel free to interrupt with your questions, post your questions on the chat box, and Prithvi will then post the questions to me. So I look forward to a very, very interactive session. And I start this session as I do with many others. And I love to quote Walt Disney here. I'm here to entertain you all. And in the process, I hope to educate too. So look forward to a roller coaster, and here we go from here. So what were the things I wanted to share with you all today? We are primarily being hosted by the Madras Bar, the tax bar, So I thought I will focus my presentation today on cyber crimes in general. So it will include individual crimes and also financial frauds. When I'm speaking about financial frauds, I am primarily touching upon the interplay between the cyber domain with the commission of crimes. Whilst doing this, I will be primarily, and so here is where the sessions may get a bit heavy, but it is still very important because some of these issues I've been touching upon since about 2003, after the 2000 Act came out. And unfortunately, many problems that ail the IT Act remain till date. I am addressing a substantial number of tax bar practitioners. So it is right that I put in the disclaimer here that when I am saying IT Act today, it is always the Information Technology Act. If I want to say Income Tax Act, I will specify that, in full. So with that qualifier, moving forward, nothing about cyber crimes or enforcement can be complete without touching upon electronic evidence and jurisdictional aspects. So time permitting, I'm hoping to touch upon at least the primary issues or concerns with respect to the disharmony between laws of India inter se. We are not even talking about international laws here, but inter se Indian laws, which cause a lot of struggle when it comes to enforcement processes. I will be ending today's session, as I have the book also, with my theory of broken windows in cyberspace. And I have in fact relied on Justice Sri Krishna's quote in my book when I've spoken about how, the law may hang limp, it seldom barks and never bites if enforcement is ineffective. So I will be touching upon international soft laws and enforcement mechanisms and how India can be a forerunner in terms of leading the fray for ensuring that we have better enforcement. Because when we talk about cyber crimes, we are always speaking multi-jurisdictional issues. So with that, let me get you all started on the first introductory phase of it. Now, when we talk about the cyber world, and this is how I started my book also with this concept of cyber Pangeanization. The whole construct of Pangea is that the world was one and the continental drift separated all the continents and moved all of us apart. Ice Age, if not anything else, gave us visual recall for the continental drift. But I call it the reversal of the continental drift in my book. And I say that what the continental drift separated, cyber brought together. So it converged and coalesced us into one, and it killed distance. So today, if we are doing this conversation in the morning in India, we are probably addressing audience across the world at night. And we are working always. So when you read the book on Death of Distance, the author speaks about how the world never sleeps now because cyber has ensured that work is continuing in some part of the world. Everard, the author, talks about how the coalition of the cyber world that the cyber world has brought in with respect to jurisdictional issues has actually made the concept of statehood wither away. So he says, wither the state, where is the state? And do we really have this concept of statehood considering the seamless or borderless cyber domain? Now, the issue that arises when you have a borderless state is that technology enables better connectivity. Technology has helped us all to stay connected today. We are seeing the importance of technology, especially during COVID times, as I call it. But there is always a flip side. Nothing comes without a price, right? And the price here that we are paying is the much wider reach that criminals have and the kind of crimes that people can commit with just the click of a button. What are the weapons that we have in hand to combat this kind of crimes? And how are we going to deal with it? Be it as, and this is where I wish to digress to explain also who am I addressing today and how would I like to address it therefore. I would like to first address the issues that I'm raising for each one of us as users of this technology, as each one of us as possibly victims of this technology. And believe me when I say that probably all of us are victims, we probably are. And each one of us as practitioners who are going to be helping victims. So in the introduction, Jayalakshmi mentioned about me being founder of Saathi. The whole construct of Saathi, or as it translates, cyber friend, is all about being a friend there in need when somebody falls victim. So the whole construct of Saathi, and that is going to be the structure for today's presentation also. And I'm just skipping through to this slide on that, which is that when it comes to cyber crimes, prevention and protection are the primary focus. You're always better off preventing and protecting. And the third and most important aspect, which I put as preserve, and what we otherwise call as resilience, the easy bounce back. How quickly can we bounce back from a cybercrime, whether it's an individual, company, or critical infrastructure? That is what will dictate how well prepared we are, and it leads into the earlier two which I've mentioned, which is prevention and protection. And today what we are going to be focusing on predominantly, which is the punitive aspect of it, or prosecutions. So when I'm addressing these aspects, and you will hopefully, and tomorrow is my launch date for Saathi website, you will hopefully have a lot more information there, which I may not be able to cover today. And the whole idea is to share and to prepare each one of us to stop us from becoming victims. And if, unfortunately, we do fall victims, we don't immediately run to professionals. The first person we reach out to is probably not even our parents or even our siblings. We will reach out to friends. Even in those instances when we reach out to siblings or parents or some authority figure, we do so because we treat them as friends. And the whole idea of Saathi, therefore, is to make that friend, and which is every one of us, prepared to meet that challenge, at least as a first level, or like a first aid, or the first level of protective measure. So the two slides I skipped are also important, and I always love to say, as the song goes, that we should always start at the beginning. And fundamentals are very important, which is that when we talk about a criminal justice system, what is it that it is intended for? It is intended primarily to deter people from committing crimes. I would love to give this example of the policeman who stands beyond a signal and hides himself probably and jumps out after you break the signal. That is counterintuitive or counterproductive. The whole idea of having a signal which is supposed to regulate you by itself and then putting a policeman there to ensure that it is regulated is to protect and prevent and not to punish. So therefore, similarly today, law is meant to deter people from committing crimes. It is not meant to just punish. We are seeing this situation right now where children are being tagged as criminals today. What they did was not acts of children. What they did does amount to crimes. I will be covering that in one of my early slides in terms of the cybercrime, general cybercrime angle. But the fact remains that they are a bunch of children who probably thought they were just having fun within four walls. It actually leads to one of the earliest cases we had in India, which is the Air India Bal Bharti case, where a child was probably subjected to bullying in the real world. He had suffered from smallpox and he was being dragged as porky, etc. And probably he was upset about his teachers not protecting him because there is no other reason to give for what he did later. So he creates an intranet within his school, and this is a school kid of Air India Bal Bharti school, and he takes his friends and teachers, the lady and girl students and teachers, pictures from Facebook, morphs them into nude or sexually explicit content, and then shares it in the school intranet. Now, when the issue about releasing the child on during the conduct of the juvenile proceedings, the Juvenile Justice Board observes, and this was reported in fact, that what the child did was effectively like bathroom graffiti. So like how children would just go into the bathrooms and scribble whatever came to their mind, this is all he did, but he did it on the digital domain, and therefore he should not be punished with incarceration during the proceedings. The difficulty here is that these bathroom walls, whether it's the boys' locker room, girls' locker room, or any locker rooms, whether it is those innumerable WhatsApp groups which are dealing with child pornographic content, whether it's content like that or offensive content against women being uploaded on social media sites, they are not contained just within four walls. They unfortunately escape all over the world. I am appearing as amicus curiae in this matter, which is for short Prajwala versus Union of India, but otherwise the citation is Prajwala letter dated 18/2/2015. I was inducted as amicus in the matter in 2017. From then to now, there has been a lot of changes we have brought about in terms of governmental intervention in cases like this, primarily of rape and gang rape videos being uploaded online, and of mitigating child pornographic content online. And I will be coming to the kind of impact this case has had. But the one thing that came up during this case were two aspects. One, that which all of us have grown up believing, and we still strongly believe in, because without that, we cannot be legal practitioners. That faith in liberty and democracy, right? That faith in free speech and freedom of expression. But when we talk about free speech and expression, we also come to this issue of where does that line stop? Where is that stretch of my hand to the other person's nose? Today, when we are talking about the digital domain, unfortunately, that nose has come much closer. Everybody is in your bedroom, everybody is in your private spaces, because you have allowed them in with every single device that you bring into your private space, whether it's your home or an office. So the first proposition I'm putting here as deterrence, and why I'm talking about the Prajwala case here, is we realize that here is a case where people who are committing gang rapes are not just videographing it and putting it online. They are actually directing people to ensure that they are shown properly in the video and then uploading it online. Why would they do that? I came across these cases first in 2015 when I was doing the chapter on crimes for my book. And I just couldn't believe it. And then when I did a Google search, I found this one site. I've given the link also in my book, on YouTube. So we're not talking about the deep and dark net here. It's on YouTube, and with a caption which says, Lajpat Nagar lady gang raped by 7 people or something like that. Thankfully for me, till date, I've never had to suffer having to look at any of those videos. I don't think I will be able to come back from that seriously. But what I could see on the YouTube site was that there had already been 6.5 lakh views. And after that, it has been blocked. So that girl was not violated once or 7 times, but 6.5 lakh times and more. So this is what I mean by deterrence sadly lacking, and the broken windows theory, which I mentioned about earlier. Because if there were, or if there was effective deterrence, then these people who are committing a crime, which is a crime in itself, will not commit the further crime of uploading this content online and providing evidence of their crime to millions. They are doing it with such confidence that they will not be punished for it. So what we need today, and what the entire thread, which will link everything that I would be saying today, is this need for enforcement to be effective and visible, for justice to be done and seen to be done, so that it acts as a deterrent against crimes in the future. Now, going forward to protecting and prevention, and how are we going to go about it? And this is a given. It's a very old slide, this one, but it still holds good. Crimes. We did not have a definition of crimes. And I believe India is on track in saying we don't really need a definition for cyber crimes. Some jurisdictions have come up with definitions for cyber crimes, but broadly the Kerala government's advisory captures it best. And I have also, and this is something I've been saying always, and I reiterate that here, that one could say a cyber crime is where a computing system or a device is a weapon or a victim. And today that computing device has become much wider than where we started. Today, even your baby monitor is a weapon. Even your security camera is a weapon which can be turned against you. What you put for your own security can be hacked and turned to violate your privacy. So we have before us a whole horde of cases which walk us through this very difficult situation of where we draw the line. And this is the case I was telling you about, where what the boys shared was definitely not bathroom graffiti. I have written on this, and I'm hoping the article will come out soon. Very briefly, what I have espoused here is that the actions of the boys, where people are making it seem like a boys' locker room versus girls' locker room is somehow going to, two negatives are going to make a positive, is not going to happen. The difficulty for the boys is here. Many of the provisions under IPC, which were introduced particularly after the Verma Committee report, are all gender specific. You have sexual harassment, you have voyeurism, you have offenses for disturbing a woman or through assault, you have all the rape and gang rape and whatnot. All of these are gender specific. So if there is anything which links to a gender specific offense, then the boys are going to be more liable than the girls. Secondly, we need to distinguish between sexuality and sexually explicit comments versus criminal content, where there is some form of inducement or encouragement to commit crimes. When we talk about offenses under the IT Act and also under POCSO, the Prevention of Offences Against Children Act, so you will find that the provisions are more gender neutral, and in that sense, it impacts or helps to protect children of both genders. But when we talk about why such things are happening, I thought I will again go back to basics. When we talk about the social contract theory, we always think it's only about this. I give up my rights so that you will protect me. Of course, this is slightly funnier than that, but then I was very intrigued when I came across this Glaucon and Socrates quotes. It is not just about me giving up my rights so that you'll protect me. They go into a much deeper and fundamental problem here, which is that men would want to invariably commit injustices without the fear of reprisal. And this is why I mentioned to you the golden thread, which is going to cross my presentation always. And that's going to be about enforcement and effective enforcement at that. So they want to commit injustices, but they don't want injustices committed against them. So what they are giving up is not really their fundamental rights, etc., for protection, but their right to commit injustices so that they will be protected. I thought this was a very, very interesting construct. And the boys' locker room case and many other cases, which I'm just putting up now, in a way indicate that kind of a social mindset, which may have to be addressed in a completely different way. One remedy, of course, will be to show that certain things are crimes. Two, to show them that they can be tracked and traced. And three, that action will be taken effectively, speedily, and to its conclusion quickly. So what are we faced with today? We had a situation where we were dealing with 3,000 child sexually explicit or sexual abuse material in 1998. And by 2018, and this is the date of the report, which is of 2019, it has increased to 45 million images of CSAT. And this, when you read the next line here, you will realize is only that which has been identified. Now, NECMEC, which is mentioned here, is the organization which is mandated to handle, because across the world, CSAN content is illegal and there is zero tolerance to it. India has one of the strongest laws for it under Section 67B IT Act and also under POCSI. So when you say that it is zero tolerance, even for government authorities or other entities to deal with it, to help in enforcement, they have to be permitted to receive and act on it. So NECMEC is an organization which has been allowed to receive these. And what do they do? And you will see the importance of NECMEC when I come to one of the COVID cases that I'm addressing further down. So when you talk about NECMEC, what it does is any child abuse content which is identified as shared with NECMEC, they create a hash of it and then share it with social media platforms, which then deploy it on their servers and ensure that subsequent uploadings will not be permitted. So to some extent then, this issue gets mitigated. This aspect of the hash value and blocking it is also going to be important when I discuss the outcome of the Prajwala case, because this is going to be very relevant when we look at some of the other cases that are coming up, and especially the Pollachi case, etc. Let's just see what it does. To begin with, Prajwala was about the uploading of rape and gang rape videos. When victims wrote to the social media sites and no action was taken, they sent the videos to Prajwala and Prajwala intervened. Even then, no action was taken. And so Prajwala sent a letter to the Supreme Court and with the videos and requesting for the Supreme Court to intervene. Therefore, this case was registered as a suo motu criminal writ petition. And thereafter, Prajwala pleaded itself in the matter. Initially, the whole issue was primarily about traditional methodologies and whether general law enforcement agencies will be able to handle these cases, or should it be transferred to CBI. In 2017, when I was involved, one of the things which I had suggested was the use of artificial intelligence, be it machine learning, deep learning, or the natural language processing, etc., which can be used as a tool to block such content at the stage of upload. And this is the reason why I mentioned about NECMEC and the hash. Now, the first stage is, and what we are talking about with the NECMEC hash and what is being blocked is called as passive blocking. So once you identify the content, you can block things in future. This is something which is substantially deployed for copyright content. Today, if you are able to deal with protecting your copyright content before it's violated, just a day or two before the movie is supposed to release, music is violated earlier, etc. This is the methodology they use. A hash of this content is created and shared with social media platforms, and this hash is deployed in the server. So when somebody tries to upload illegally the same content, then it is blocked even at the stage of upload. But how do you upload content where you do not know what the content is? It's not like you're going to know that somebody is going to upload rape and gang rape videos tomorrow, right? So what do you do then? So for that, there are studies which have evolved artificial intelligence methodologies which will use multiple parameters to identify and block content which could have sexually explicit content. Pornography, for instance, is dealt with in this manner by many social media platforms. So it was only a matter of expanding it to cases like this, where the action itself is an offense, recording of it is an offense, and uploading and circulating is certainly an offense. So there was no question of free speech or expression intervening for blocking such content. The issue, however, arose about false negatives and false positives and how much will genuine content be blocked. So my suggestion to begin with was for blocking only as a kind of quarantining and then identifying and then uploading, because today what we have are intermediary guidelines, which which give an exemption or a safe harbor to intermediaries under Section 79, and also then stipulates under the intermediary rules that one, the intermediary has to put up a notice of what is the kind of content that should not be uploaded by users, and two, that if such content like this is identified and they are informed, they have to take it down within 36 hours. Now this rule, which is Rule 3 subclause 4, came up for judicial review in Shreya Singhal versus Union of India, and it was read down. Earlier, the rule read that even users could write to the social media platforms and they are bound to take it down. But that part was struck down or read down, and Shreya Singhal, the Supreme Court held in Shreya Singhal that if the notice goes from a court or from a government authority, then the social media platforms have to act on it. Otherwise, they are still entitled to their safe harbor. But so technically what happens is if a user writes to them, it becomes they may act on it. But if the other two entities, that is a court or a government authority, writes to them, they have to act on it within 36 hours. So the whole construct in Prajwala was, if such content would be out in the world for 36 hours, then putting the genie back in the bottle is going to be next to impossible. So what we need really is a preventive or protective measure, and delaying content like this for verification and then uploading is not going to harm anybody, even if it takes 36 hours. So why not do it as an unblocking mechanism rather than blocking subsequently? However, post this, a government committee was appointed and some consensus proposals. All of this was not an adversarial action, it was by consensus. And many of the social media platforms, search engines, etc., participated in the government committee. I was part of it as an activist. And a lot of good has come out of it. And it happened very quietly. And probably that was the reason why consensus methodologies worked also. A little step here, but I'll come back to this in terms of where is the distinction in terms of how social media platforms view themselves on safe harbor provisions as opposed to how India views them. And this is where it is, where most of these social media platforms are subject to US laws, and US has an unbridled right of free speech and expression. And the Communications Decency Act therefore explicitly protects them against all this. And therefore, when we come to an Indian scenario where we believe that we have, it is a fact that our fundamental rights are not unbridled, and there are regulatory processes which can restrict it. And when we attempt to enforce that, there is resistance, and that is why this slide from social media platforms. So today, when we talk about resistance and how we can overcome that, we do have a trend that is moving. Before I come to what Prajwala did, I thought just a little bit on an aside here. There are a lot of changes that are happening across the world. Even the US, which was so particular and stringent about its safe harbor, is moving towards a slightly modified version when it comes to sharing of offensive content online. Something that addresses the Prajwala issue directly and something that India should be looking at. And one of the things I submitted in the parliamentary committee meeting was Australia's Criminal Code Amendment Act, where very explicitly the law provides for blocking of content exactly like that which we have dealt with in Prajwala. What we need today is something like this. And if social media platforms are going to any way moderate or modulate their architecture to provide for protective measures to meet Australia's stringent thresholds, it is not going to take that much of an effort for them to do it for India. The Prajwala effect and how much of a far-reaching consequence it has. So first thing is social media platforms and search engines, etc., agreed to undertake the AI research, but their contention was it was not readily available for deployment online. So that part was the first step we covered. But the second step of whether they are going to implement it or not remains to be decided by the Supreme Court. This is a case which is ongoing, and there are many orders that have been passed. But the most important one, which will give you all the guidelines that have already been passed and which has been acted on primarily by the government of India. One, in setting up their website, cybercrime.gov.in, where any cybercrime can be filed. Earlier, it was only for offenses against women and children pursuant to Prajwala. The site was set up pursuant to Prajwala. But today, with a lot of work we have done through the committee and thereafter, it has been expanded to cover all aspects of cybercrime. So you have an easy way of reaching out for your protection right here within the, as close as your fingertips, as I would say. The second thing was that the crawler technology, which I talked about, of the hash technology, which I talked about, which was meant to block forwards going forward. It also expanded in terms of these platforms agreeing to evaluate crawler technology like Project Arachnid or the Spider, which will go backwards also. So, and there is a lovely movie also called Spider, which talks about similar technology, by the way. So you have a Spider technology where once you put in the hash, it can go out and look for similar content. And that way, even if similar content had been uploaded and missed people's sites earlier, you could go backwards and also remove it. So these kind of consensus proposals were very far-reaching. And today what has happened is, what started off for Prajwala and for women protection and child protection is now also coming in handy with respect to hate speech and fake news, etc. I'll be touching upon that also briefly. A lot of social media platforms actually changed their architecture based on Prajwala. One of the most important impacts of Prajwala was India was not a signatory to an MOU with the NECMEC for sharing of this content. Because of this, people were not able to take action against India-based content. Now this MOU is in place, and a huge operation was launched in January, and I was part of it as advisor to Maharashtra Cyber Police, and Maharashtra Police called it Operation Blackface. And you can see the statistics here of how many arrests have been done, and this is an ongoing investigation. And you will see why this is important. Now, we are talking about these kind of things, and we are shocked with something like a boys' locker room. But look at the trend. When you are locked down and when you want entertainment, is child pornography that which you will believe people are looking for? 95% of men are the culprits with respect to this traffic that is emanating from India, and 1% of women. So please do not believe that child pornography or offenses like this are gender specific. They could also be gender neutral in that sense. When and how can you hold an intermediary liable? Today, the Indian government is evaluating, and we were supposed to get the guidelines in February, and then COVID happened and we are still waiting for that. But I would say one very important aspect of the intermediary guidelines that is expected to come up is not really needed because it's already built into Section 79. And the case of the Supreme Court also clearly addresses that. And so we don't really need it. But it is something which being explicit may be helpful. Now, in this case, and 79, to go to the fundamentals again, what it gives a safe harbor to intermediaries for is for third-party content. It very specifically says that if content is shared by someone else, where there was no control over that sharing for intermediaries, and that they have acted with due diligence and acted expeditiously as mandated by the central government, then they are protected. So what is needed for that protection to work is that one, the intermediary should not be the person generating the content. So the reason why this addition is expected in the intermediary guidelines is actually because of the TikTok case where they sued for violation of their IPR, claiming that this is our content. Of course, according to me, it may be a misinterpretation with respect to the TikTok case, because aggregating copyright content is not the same as generating copyright content. That's an issue which is not there for judicial review now, so we'll have to wait and see what is going to happen with that. But until then, here it goes. So the TikTok case then kind of triggers, this thought in the regulator's mind that we have to put this explicitly. And this was something that was expected or anticipated, that intermediaries will be clearly told that the 79 safe harbor will apply to them only for content which is not generated by them. The other few aspects which are already there and which may be set out more explicitly are as follows. One, that you have to do the takedown, and this is the distinction between a takedown and blocking. You will be dealing with blocking. I'll come to that a little later under section 69, 69A and 69B of the IT Act, where it is for monitoring, decryption, etc., and 69A for blocking and 69B for monitoring of traffic data. Those have checks and balances, and they can be undertaken only for a limited period of time and with a purpose and intent or restraint, etc., which are built in through the rules. Takedowns are different. Takedowns are not to be regulated through 69, 69A and B. It is under 79 and the rules framed under that. As I said, Rule 3.4, which specifically says that when a platform receives a notice from a government authority or a court, then they have to take down. Earlier, most of these notices were going under section 91 of CRPC, and many would just be no, because the platforms will then start questioning what is the stage of investigation, what is the offense. We will be evaluating it based on our parent laws, which is US laws mostly, in terms of deciding whether this warrants action or not, etc. From December 2018, when there was a pan-India discussion, I was part of that, and we formulated the whole structure. And again, through consensus processes, we've evolved notice drafts for social media platforms to act on. It has moved to notices under section 79 and rule 79.3b read with rule 3.4. So what it states and what is the implication, and this was always the case from the time of 79, which is that if an intermediary does not act with due diligence, and if they do not act on an order of a court from India or from a government authority in India, then they can be held liable on par of an abettor of the crime, right? Because if it weren't for 79, where would they have stood? They get moved back to that situation. Now, Sanjay Kumar Kedia did exactly that, where a person set up and was dealing with NDPS drugs on his website. The court held that they are not entitled to 79 because it is not like the website owner did not know that drugs which should not be sold were being supplied. And here it is about knowledge which precedes the action itself. And this is exactly what people are expecting to be reiterated in the intermediary guidelines today. Moving forward, and this is a very important issue that has arisen in recent times. And this was a bit of what we call a jatka in Hindi, or something to perk everybody up or scare everyone out of complacency. We have gotten very used to section 79 as it stands today. Everybody forgot that one case redefined the law for India. That was the Bazi.com case, because of which India decided to change its stance with respect to safe harbor provisions. Before the amendments of section 2008, intermediaries still had safe harbor, but provided they prove that they had exercised due diligence and acted with care and caution as mandated by the central government, etc. There were no intermediary rules at that time. The difficulty that arose with that was that the intermediary would still have to undergo the trials of trial and then prove them innocent. So after the Bazi.com case, 79 was amended, and now they are given the protection, and then they may be included as abettors or co-conspirators after it shows that they have not acted as per the law. Now, this is the distinction that happened. Now, what is Google India versus Vishaka? It was about defamation, etc. But the Defamatory Act was before 2008. And therefore, the whole issue was that Google was not entitled to intermediary protection under 79 as it stands today. When we talk about it this way, it may seem trite, but yes, it had to be very elaborately discussed and decided, including on another very important aspect, which is that the current provision of Section 79 clearly stipulates that this safe harbor will apply irrespective of whichever law or offense that you are dealing with. However, that non-obstante was not there under the old draft, law rather, and therefore Google now has to stand trial. Moving forward, and I told you all, and I'll be rushing through a little bit of this because I want to get to the financial frauds aspect of it. Now, when it came to hate speech and AI, a lot has happened where the world is moving towards AI-enabled speech modulation. The latest in that we will come to with respect to, I would move to this judgment, in fact, of the Supreme Court. And before we come to the Supreme Court judgment, and what I told you, the Prajwala effect is much wider, and now look what is happening with AI and what can be done. Now, Facebook has decided to engage these fact-checking partners, and they check facts and then flag certain articles. So 4,000 was what was there in March 2020. Now, Facebook then, when somebody is trying to share, post, forward, like, etc. on its platform, those flagged posts, then it gives you a warning message that this may be fake news, and if you share it, you may also be liable, etc. And look at the numbers there, 40 million posts in just 1 month. Alak Alok Srivastava was actually filed to protect the rights of the migrant workers during the COVID phase. Now, when the Supreme Court was by the government, it talked about all the facilities they're already extending, etc. And a very unexpected outcome came from that, which was they talked about the infodemic process. And again, the Supreme Court's foo here, and the government requested for some protective or directions with respect to that. And the Supreme Court put print, electronic, and social media on par in asking them to exercise a strong sense of responsibility when for preventing or protecting unverified news. The impact of this is going to be far-reaching because we're going to have to wait and see whether this statement of the Supreme Court is going to be interpreted as ratio, and will many social media platforms or people be liable for contempt, or is it going to be treated only as an observation? Now, we come to a little bit of the heavier stage. I hope you're not thinking, oops, heavier than what is already there, because I do hope to go into some of those interpretative aspects, which I mentioned I will be walking you all through. Now, there was a very basic issue which again gets forgotten with passage of time. When India introduced its 2000 Act, unfortunately, though the whole world was already facing huge losses because of cyber crimes, their focus, or the law draftsman's focus for India, was still about enabling e-commerce. There were all of 10 provisions under Chapter 11, if I'm not mistaken, for what we colloquially call cyber crimes. Some provisions were also added under IPC, like forgery, etc., and which is why I call it a cyber law jigsaw, because you're not going to find issues of cyber law only in one code. It's spread all over. So that was also done in 2000. But many, many issues such as hacking and let me just stick to this. I'll move forward to this slide and then come back if necessary to the other slides. Sorry, I'll keep it here because it's easy, because these are just the taglines here. And these are literally the 4 slides you're going to see on this section specifically today. So, you had these instances of hacking and data theft and virus attacks and denial of service attacks, etc., which had already caused huge loss. But under the 2000 Act, all of this was a civil penalty under Section 40. 2008 amendments that these were made into criminal offenses. And even in 2008, it was not immediately effective. It came into effect only in 2009, October 27, 2009 to be very precise. And when it came into effect in October 27, 2009, it was done as a reverse, kind of reverse engineering. What happened was there was a Section 66 earlier which said deleting, destroying or altering data or diminishing its value or its utility or affecting it injuriously by any means. You will find it highlighted here. Now, it was such a convoluted definition with the heading of hacking, and everybody protested this draconian law and expected it to be deleted. What happened instead was this was added as a subclause in 43 along with the modified version of Section 65, which deals with tampering with source code. And then it was read backwards again into 66, which was modified to say, if any act under 43 is committed with dishonest or fraudulent intent, then it will be an offense. Now, the problem that arises with the old law of Section 66, which now is Section 66 read with 43I, is that it has a mens rea because of the dishonest and fraudulent intent, but the actors is kind of missed out. Because the first part of the provision deals with deleting, destroying or altering information, but the latter half deals with consequences, which is diminishing a value or utility or harming it injuriously. But the conjunction which connects the two is or and not and. The difficulty that arises with this is then, is it that, any kind of diminishing of value or utility can be an offense here? Or is it that if you diminish the value through deleting, destroying or altering information on a computer resource, it is an offense? I have interpreted this or as and because without the and, even if I throw a computer down and break it, I could be diminishing its value. And if I do it with dishonest and fraudulent intent, it's an offense. And that would lead to very absurd consequences. If the first part is to be read with the second, one would assume that the first part being the action and the latter part being consequences, they would have to be read together for it to make sense. I've also discussed, but I won't go into that aspect now, in my book very extensively on the fine delineations between stealing, concealing, destroying and altering source code over here in 66 read with 43J, as opposed to concealing, destroying and altering source code and tampering with it under Section 65. Predominantly, most of these are used interchangeably. We also have these other provisions which were added under the new act, which was for identity theft and cheating, etc. I'm going to walk you all through case laws and analysis for this. Again, going back to basics. And if any of you have some questions, please don't hesitate to interrupt me. We are already 45 minutes into the session, if I'm not mistaken. And I would love to take questions if they're already up.
Ma'am, I have got few questions, but I think those were more on general than particular topics which you're dealing right now. So I thought I'll just put it up at the end.
Sure. Then may I continue?
Yes, ma'am. Yes, ma'am.
Perfect. So, the reason I'm referring to these three judgments here, Khatar Singh and Maneka Gandhi, are primarily for this reason, which is that a law has to be simple and not vague, and it has to be easy to understand. If I have to interpret the law to apply it, then I don't even know what is the offense that I'm committing when I'm doing something. And ex post facto, I'm going to be held liable. So this is where clear and precise laws and clear and precise interpretations or simple laws and easy interpretations will help in enforcement. Again, the golden thread which says that we have to have effective enforcement for laws to be really adhered to. Now, what I already pointed out with respect to 66 and with what happened with the reverse engineering that was done is that you have a capture all kind of provision in that I, which allows you to decide ex post facto whether somebody has committed an offense or not. It would definitely help better if people know that if they are taking away data without the permission of the owner, then they are committing data theft. If they gain illegal access, unauthorized access, then they are committing hacking. If they commit a distributed denial of service attack, they are committing an offense. For those of you who may not know what is a distributed denial of service attack, I will touch upon that very, very briefly. Let's go to specific provisions here with this interpretation which I've given with respect to 43I, where I've already pointed out how it is so convoluted that nobody is likely to know how or in what manner they are supposed to have committed an offense until a case is registered. There was one of the most absurd cases that came up in Mumbai, where a lady was arrested and a case was filed saying that she had deleted data from her own computer. The reason why this case was registered was that data was supposed to pertain to cricket betting, etc. But because they could not establish the offense further, she was let on bail and we have not heard anything about the case thereafter. So this is the kind of absurd situations we can come with if we don't have effective interpretations. And I thought in COVID times, nothing explains how people can interpret something more than this picture here, right? Moving on to financial frauds. Isn't it indeed much easier to gain your illegal access online?
Ma'am, I'm sorry to interrupt, ma'am. There is one question with pertaining to section 66. Can I just read it out, ma'am?
Sure.
Yes, ma'am. So the question is, bank uses CBS staff of banks to have access on all accounts of the customer. If without any work or activity to be performed, can the staff access that account to watch the operation? Does it fall under 66 AS as internal hacking?
No, not really. Hacking, as you can see, is qualified with the first line, which is that without the consent of the owner or the system administrator and unauthorized access to systems. What the question seems to really be raising is with respect to data protection and data breaches. So when you talk about data protection, today we have literally one provision which is for criminal and one provision for civil laws which deal with data protection. I'll jump the gun here to that because it will address the question also then probably. Section 43A, which was introduced through the 2008 amendments, is the civil provision, and 72A, which is the criminal provision, which again was brought in through the amendment. Now, 43A talks about a body corporate violating personal data with respect to sensitive personal data, to be very precise, and as set out in the SPI rules, which were formed under 43A. And wherein through negligence of the body corporate, it's a negative provision and not a positive protection, and where it may result in loss, etc. And that negligence or violation has to be based on a contractual term or a law in place. Now, 72A, very interestingly, deals with violation of personal data. See, when I think of a criminal provision and a civil provision, I would expect the criminal provision to be for a narrower sphere and for the civil provision to be for the broader sphere. Whereas here, you have the narrow sphere of SPI or sensitive personal information under 43A and the broader sphere of personal data being covered under 72A. Now, when you look at the requirements under the law, again, it is about in contravention of a contract. Now, when a bank employee is looking at your transactions, the system is within the control of the bank and not your control. This employee is authorized by the bank, and therefore 43 read with 66 is not going, 43(1)A to be more precise, read with 66 is not going to be. It is also not in violation of 43A or 72A because it is well within their contractual right to do what they are doing. However, when that employee or if that employee were to violate your right by sharing this data with third parties, then it will amount to an offense. And that is the stage it becomes unauthorized use. And that would be more under 43(1)(b) of data theft rather than of hacking.
Thank you
Anything
very
else,
much.
Prithvi?
No, ma'am. I think it
We'll
answered.
move forward? Yeah.
Yes, sure, ma'am. Thank you so much.
Thank you. So just moving forward with the Cosmos Bank case, this was a case where the SWIFT switch was hacked and therefore ATMs across the world were compromised. It is one of the most complicated and sophisticated cybercrimes that has taken place. Not all cybercrimes, however, are that sophisticated. You may have some very simple hacks, and most of our systems, I always quote I always rely on this quote, which is Kaffenberger's, which goes as, there are only two kinds of systems, one that has been hacked and one that is waiting to be hacked. And I always say that there are two kinds of systems, one that has been hacked and one which you don't know it has been hacked and you will get to know eventually, right? So when we go forward, and this is one of the scariest and one of the most far-reaching hacks that happened of Sony. And the background to this hack was that they were going to release this movie, The Interview, and the hack was attributed for blocking that release because it spoke about premiere and of North Korea, and that is the attribution. At least we have to wait and see what the outcome is going to be. But anyway, the systems were hacked and they were threatened saying either do not release the movie or we will release not only all your copyright content but also your financials, etc. What Sony did was they just released it online instead of in theaters, and they almost kind of called the bluff. Of course, financials were released thereafter. There are some very interesting cases of hacks, including one of the most interesting turnarounds. You have to look up the Ashley Madison case. This was a site which was encouraging people to have affairs. So a vigilante online decides that he doesn't like it, so he hacks into their system and then informs them very religiously, saying either take down your site because this is immoral what you're doing, or I will be releasing all this information. The site did not take him seriously, and so they did not bring it down, and he released all the information. Apart from a lot of cases being filed against the website Ashley Madison, it also resulted in a lot of diverse cases being filed. But the curious turnaround in this case was this. You would expect Ashley Madison to close down after this, right? But that's what didn't happen. What actually happened was it became more popular, and probably they just decided to improve their systems. Moving forward, one of the hotbeds for cyber crimes, and I was, in fact, when I shared the information of today's session, somebody also talked about the Netflix series about the Jamtara cases, and believe me, they are true. I have addressed sessions in Jharkhand, and I can tell you it is a very serious issue. Now, this is just one small instance of cloning of ATM cards and using those to withdraw monies, etc. The reason I put Jamtara after the Cosmos Bank attack was to show how very simple phishing attacks, which is phishing using telephone communications for getting your OTP numbers, etc. The Jamtara attacks are becoming more and more sophisticated. So today, if you have a problem, what would you do? You would go to a website of that service provider, you look up their contact details, and then call the numbers which are mentioned there. So the Jamtara crimes are evolved to hacking into those websites and modifying the contact pages there, so that when you are calling for a problem that has been created by a criminal from Jamtara, your call is also probably going to that criminal. So this is how evolved they have become. These are two cases which are my favorites when I come to financial frauds, etc., and corporate crimes. You would not relate hacking with an insider trading case, right? Here are the cases on this. So in the first case, there is an individual who thinks of this interesting idea, and he hacks into systems before they are likely to make public announcements of their financial statements, right, after their annual general meeting. And then he would play the market using this prior information and made a lot of money. And with, this repeated actions happening from only one vector or one source, some suspicious broker found out and this person was arrested, and he in fact was convicted. But this is just one person using hacking as a very, very effective tool to commit crime. In the second case, it is a racket which went on nearly for 1 year, where a set of hackers were hired by a set of brokers who said, now get me this information. The hackers decided, oh, companies may have very strong hacking, security measures. So let me figure out other alternatives. And who do they reach out to? The PR agencies. And they hack into those things. And most of the companies would share their statements, the press releases, in advance with their PR agencies. And this is what the hackers targeted and shared with the brokers. And through this wonderful collaboration, they made more than $100 million before they were caught. Cute is definitely not safe. So if you're clicking on those cat videos or of dancing pigs or of other kind of explicit content, be very careful, because you do not know what you're downloading onto your system. And this is why I said that systems can be compromised and you may not even know about it. It's not just about what somebody else is doing, and ransomware is one of the biggest outcomes in terms of how this kind of an offense hits you. I'm moving faster because I want to talk about all these cases in the light of COVID now. What do you see when you talk about, a COVID-inspired case, right? And this is what we are seeing in just 1 month or more, slightly more, right? You have cases of phishing attacks, and these are mostly through either emails or through websites, which you do not know are contaminated. So you are downloading malware along with all your paranoid checking for COVID maps or COVID news, etc. You also have 2 apps which the Ministry of Home Affairs has warned you against in saying, beware, do not use these maps. You also have a crypto hacking or cryptojacking tool which is sent to you by email and which can take away your cryptocurrency. So these are all frauds which are emanating in times of stress. And that is the reason why whatever you download, including a Zoom app, you really need to be really careful. Just going back a little bit to some of these cases, a hacking or a virus attack could happen in large scale the way we have seen in terms of a Cosmos Bank, etc. But it can also be a very, very small and individual operation. I have dealt with cases which would be an individual exceeding access in a company and, illegally misusing that content. There are cases where people have walked away with the entire data of an entire branch of a company and set up a competitor the very next day. And the curious aspect of one of those cases was the entire team of employees also moved. It wasn't just the data that moved. There are also the flip side of cases where today we are talking about work from home, but there are cases where you're allowed to work from home even otherwise. Everybody is meeting deadlines and no company complains when you're working 24/7. But the minute you leave the company, you join a competitor or you become the competitor, that very same action of yours of being very committed can come to bite you in the back. So you may be held liable for actions done very innocently. So when we deal with both kinds of cases, the one median or a balance I would suggest would be if companies would be fair and ensure that very effective and detailed policies are in place, which will ensure that employees will know what is permitted and what is not. If they don't, then it is just going to be unfair to the employees with respect to what they are going to come. I thought a lot of you may be interested in knowing about cryptocurrencies and the IAMAI decision, though that was not really on the cybercrime aspect, though criminal cases were registered based on the RBI circular. Now, the IAMAI case just struck down an RBI circular which stopped banks from dealing in cryptocurrencies. It did not put a ban on cryptocurrencies the way it was touted. The Supreme Court went into it, rejected all other grounds except one, where they held that the way in which the RBI issued the circular was disproportionate, and therefore it had to be struck down. I personally feel that if this judgment were to be reviewed on the angle of even maintainability of the case, it may suffer on this ground particularly because the very explanation given by the Supreme Court to demonstrate disproportionality of the circular pertains to cryptocurrency exchanges and not to individuals. So with the caveat that Article 32 can be invoked only by citizens and consequently individuals, and if the impact of disproportionality is being mounted purely for exchanges which are organizations, and with case laws already there that you cannot lift the corporate wheel to apply it for the shareholders of the company or for their benefit, I would say that it would definitely suffer from maintainability if it were subjected to review. But as on date, with the RBI's circular gone, people are expecting that exchanges will be effective immediately. But this kind of just trading on exchanges is not the real issue we are faced with when it comes to cryptocurrencies and crimes. There is a very large case which is being dealt with by the Pune police. And this is like a Ponzi scheme, buy one, get one free kind of thing, but on cryptocurrency. So it's a 2,200 crore scam which is being investigated, and many cases have come out, but predominantly all the high court cases that are there are with respect to bails and anticipatory bails. Moving forward to some of the things which I believe, move between domains now, and I'm here to point to some of the tax cases and electronic evidence issues here. And I start with the simple VAT, the single point to the multi-point process. And I always say that, when it comes to tax cases and to tax evasion versus avoidance, it leads to some very interesting cases. I'll just point to one case only to show how an electronic trail will help you in any kind of case, and how these, a vertical, which is cybercrime, can become a horizontal, and electronic evidence always remains a horizontal form of practice across multiple, expertise areas. Now, here is a person who thinks he's being fed. This is a Bombay case, which the ITAT was dealing with. So this person is dealing in Benami transactions, and he thinks the simple code of just giving a code name for the person in his systems will keep him safe. And of course, sometimes they also put it behind hidden files, etc., which are very easily trackable. Now then, during the raid and investigation, they find this coding in the computer files, and they don't know who it relates to. So then they also find that, when they do the raid, they don't just see computers. They also seize your mobiles and pen drives and whatever is around. Now, this was a very smart methodology of investigation, where the IT officials took all the codes and checked the mobile phone. And simple codes here, apple to apple kind of thing. What this person had done was he used the same codes in his mobile phone, but with obviously the genuine phone numbers of people for whom he was doing this Benami transactions. And the minute that was available, of course, I would strongly advise you all against using Truecaller, because again, that comes with a lot of vulnerabilities. And secondly, Truecaller is only an aggregator of content. So you cannot necessarily assume that whatever name you get is the real name. It is just something that somebody has entered in their system where it has the Truecaller app. But in any event, the authorities got the numbers and the names of the persons behind that. And this is how they cracked the code and they were able to apprehend all the violators. In an when there was some kind of a leak of information, probably which resulted in this person destroying the hard disk before the raid, the IT officials still retrieved the destroyed hard disk, and they found that it had been formatted more than 10 times, over before it was destroyed, etc., because it was like burned, stomped over, whatever. But they were still able to recover data with respect to all the violators, and they recovered 1,368 crores. So when you look at most of these cases and some of the other cases also, which are very interesting, where a claim was made with respect to foreign transactions, and the name that was used by the company in India was similar to the one which was the name they were using for the Dubai office. They actually sent people to do a physical verification. So this is these are all cases which show you that you cannot have one trail for a cybercrime or any crime. You will follow the money trail, which is always the easiest trail to follow. You will also look at multiple options with respect to electronic records and paper trails and physical proof when you are doing investigations. So in this case, when they checked physically and found that the Dubai office was just a sham of one desk with nobody there, then they were able to catch the culprit. So just on an aside with a few of these cases. And yes, there are also case laws that are coming up from ITAT with respect to reliance on electronic records. In many instances, of course, when it's a tribunal, you don't have strict rules of evidence with respect to electronic records, but it can be relied on. Since we are on the topic of electronic records, before I move to 66A, etc., very, very quickly, we are always stuck with this whole discussion with respect to Anwar versus Bashir and Shafi Mohammed and the Arjun Pandit Rao case, etc., where the Supreme Court, a 3-judge bench of the Supreme Court, is still going to decide with respect to the legality of Shafi Mohammed's case. So today, if it is a 3-judge bench, which is what it is, Anwar versus Bashir cannot be overruled. So we are going to be faced with, and this is the reality of today, that you have to comply with all 3 aspects in section 65B4 for the certificate and the 4 parameters laid down in 65B2. But remember that electronic evidence goes way beyond section 65B. Section 65B is just the first threshold. And in Anwar itself, the Supreme Court very clearly laid down that all you have to prove is to the best of your knowledge or ability. You do not have to prove beyond that. So when this is the situation, what is it beyond section 65B that you should take care of? Very, very quickly, because I've already addressed a detailed session on that, and which I think is available online. You need to know who has to give the evidence, how should it be presented, what should be presented, how and in what manner can we ensure that it is accepted online, accepted in trial. Once that aspect is covered, then you have a much stronger case, and I can definitely tell you electronic trails are way stronger than paper trails. Because when you rely on an electronic trail, you still have metadata, you still have logs, which you can show to show when a document was created and when it was modified, etc. I'll show you some cases also with respect to emails and all. Moving on, all of you know 66A was struck down by Shreya Singhal because of its abuse. Unfortunately, there was a flip side to it. Forget about the abuse. Take the section as it was. Even then, it could not be sustained because it was so open-ended and ambiguous. But if that ambiguity had been corrected, India was the first to have codified law for meeting cyberbullying directly. This was also the provision which was being applied for dealing with cyber stalking. But today, with section 66A having been struck down, you still have remedies both for cyberbullying and cyber stalking, because you would go back to general laws under IPC, as well as the provision that was introduced under 354C for in the 2013 criminal law amendment. So when you look at the situation as it is today, you can see that there is a lot that can still be availed of despite 66A being struck down. Unfortunately, striking it down in 2015 was still not enough. It just kept continuing to be applied. So in People's Union for PUCL case in 2019, the Supreme Court again gave directions for ensuring that 66A is not invoked. But there is a very scary trend that I keep seeing nowadays, which is that 67 is now being invoked instead of 66A. 67 is actually on par with 292 and 294, etc. It deals with obscenity. It has nothing to do with offensive messages, etc., etc. So when it is a defamatory post, a defamatory tweet, a defamatory statement, you still have to go under section 499 for criminal prosecutions, which is a private prosecution and non-cognizable, and it cannot lead to arrest, etc., by invoking 67 instead of 66A. Moving forward really fast, because I would like to also focus a little bit on cyber terrorism now before we move forward. We have a lot of cases that have evolved with respect to identity thefts and how it can be dealt with. One of the earliest cases that Bombay dealt with was very interesting, and it was tracked to a corporate individual in Gujarat. It was a very scary case. So this person picks up a kind of relationship. When you look at the movie Mitra, My Friend, after you see this, you hear of this case, you may look at it with different eyes. So this person befriends a girl online. And then after some time, he gets a message from the friend of that girl saying that, I'm very sorry to inform you that girl committed suicide because, she was very frustrated that you were not breaking off your marriage and there was no future in your relationship. And she has blamed you for the suicide. But you don't worry, I'll help you as much as I can. And this help led from a few lakhs in the beginning to almost 95 lakhs being siphoned out of this person under the pretext of helping him with a case that has been registered by the Bombay police. The person comes down finally and then says, look, I've had enough of this, I'm surrendering. And the Bombay police ask him, for what? And then they start investigating and they find out, no surprises there, that the first girl is also this guy from Gujarat, Ambuja Simmons. And the second person is also the same person who was impersonating online to commit this fraud. Now you have 66C for identity theft and D for cheating by personation, which deal with cases like this. And there are many. One of the earliest cases, in fact, traces itself back to Madras in the Suhaswati case, which was also one of the fastest convictions upheld by the Madras High Court. The reason I wanted to move forward again to 66F is the reason that, the second part of 66F is just a time bomb waiting to burst, according to me. Now, 66F was introduced, and this was the reason why the amendments were rushed through in 2008 because of the Bombay attacks, etc. And they felt we needed a specific provision for it. But when we look at the situation of 66FB, you will realize immediately that they've just copy-pasted Article 19.2 and made it into a terror offense. So defamation, contempt of court, incitement to an offense, etc. are also part of a cyber terror provision. I believe that 66F, the first part, which brings in the actors as well as the mens rea aspect, and this is the part which Shreya Singhal deals with in its judgment. When it, in the passing says, see, 66F is fine because of this, but not 66A, it ignores 66FB, which doesn't have the same mens rea imputed into it. And it also just copy-paste 19.2 as if just reproducing a provision is going to save the section. Now, this is one thing which is going to remain with us for a while, but I can tell you this much, that we are going to be faced with a lot of problems because already many cases are being registered under 66F. I'm just going to walk you all to this one case because most of the other cases can be sustained, but this one case, I believe, cannot be sustained because you can't get the details of this case. It was withdrawn as settled. But when you look at all the other provisions, you can clearly see why 66F could not have been invoked. It is clearly a matrimonial offense, and terrorizing your wife or husband does not necessarily mean you can invoke 66F, right? Moving forward, there are many of these very worrisome cases. But the reason I just wanted to pause for the Pollachi cases, a lot of issues which the Madras High Court was dealing with at that time had already been dealt with in Prajwala's case. But the Prajwala order of October 2017 had not been addressed with this respect. And today we have these cases as well as the tagging of identity documents with social media platforms, etc., to be decided by the Supreme Court. But we need to wait and see how and in what manner the kind of remedies that are being applied for fake news, etc., are going to be used for blocking of such illegal content being uploaded online by social media platforms. Moving forward, and just to pause here, again, this is one other excellent judgment which keeps victim rights in focus. Now, Supreme Court, when it was dealing with Nipun Saxena, was dealing with two different aspects. One is with respect to rape and two was POCSO cases. Primarily, the directions that were given by the Supreme Court in this case are pertaining to the handling of the content that arises from these cases. So one of the earliest cases I dealt with was a morphing case of a young girl. So the very first application we moved before the trial court was for sealing of the content that has been submitted along with the charge sheet until, and for only reference to it in trial, as and when required. And the application was allowed. So here is a case which sets out the guidelines with respect to how sensitive content should be dealt with. This again goes to effective enforcement because most times victims are not willing to file cases because they say that, okay, fine, so one person or 1,000 have seen all these images. But if I file this case, what if millions see it? What if it gets leaked? And that is what happened in the Pollachi case. And that's why a PIL was needed to protect victim rights. So when victims have these kind of fears and they are denied justice because of these rightful fears, it is for systems to evolve to ensure that they are given not just the protection, but also the confidence that they will be protected and that they're not going to be subjected to more violations of their privacy and dignity going forward. Now, these two judgments again are Bazi.com, and the Digumarti case, again, as with the act in the beginning, has brought about a huge change. Now, Digumarti's case actually dealt only with one aspect, which was that if 67 of IT Act was already quashed and case was proceeding only with respect to section 292, then can it be said that, that which was not an offense under 67, which is literally similar to 292 for publishing or transmission of obscene content or through electronic medium, if that was held to be not committed and where the accused has not done any kind of circulation physically, how can an offense under 292 lie? So when deciding this, the court primarily went on the ground for the same action. If the special law is rejected, then the general law cannot be applied. Now, 81 is the non-obstante clause where the provisions of the IT Act will prevail. So if you had 292 and 67 in the same case, only 67 will apply, not 292, because they deal with the same situation. Now, this case has been dealt with by the Bombay High Court in another case of Gagan Sharma, where the court has held that special as was set out in Anwar versus Bashir, etc., obviously overrules the general. And therefore, when a criminal case is being filed with respect to IT Act offences, then you cannot invoke general provisions of IPC. What remains to be seen, because this case is now being used in many other cases also and under other criminal provisions under special laws. will it have to be apples to apples for this to apply, or can it be done even generally? One of my earliest articles was on this theft a crime, and that would seem like asking the obvious, but my analysis was with respect to whether if 43B is there and the IT Act, can 378 and 380 IPC be invoked? And my argument was 379 and 380 in any event cannot be invoked for the theft of digital data, because there are two things that 379 and 380 mandate. One is taking out of somebody's possession and into someone else's possession. In digital theft, what happens is you take it into your possession, but not necessarily out of somebody else's possession. At that stage, when I wrote that article, the amendments had not come in. It was only after the 2008 amendments that data theft under 43 Redwood 66 became an offense. So today, with 43B, with 66 being an offense, one would say definitely 379 and 380 may not apply. But as I said, Digumarti's case will have to go through a lot more interpretation before we see the outcomes on that. A lot has been happening in the Supreme Court when we talk about cyber crimes and evolution of law. In Sneha Kalita, the court was faced with this very difficult task of trying to figure out solutions for blue whale. And with blue whale not being something like this copyright violations on URLs, even if they are popping up from multiple places where you could use hash values to block it, here was a situation where things were happening in random places. But there is an interesting, take on this. Now, one of the scariest videos that was doing the round beyond blue whale was Momo threats. So there was a Peppa the Pig video, which is actually targeting very young kids. It is torture for adults to even watch that video otherwise. It's very basic and childish. Now, in the middle of something that is probably targeting very small children, you have this very scary face popping up with its eyes popping out and then asking you to, commit self-harm and probably kill yourself also, and etc. Now, these things are coding. So now if you have a video that is uploaded online and that has been modified, the person who uploaded the video online has the original code. So we may not have the codes for the content that is now being introduced. Of course, you can do it going forward and backwards, as I told you in the particular case. This was why I was saying it had far-reaching consequences. But even to begin with, you can always have some form of verification methodology where when you are uploading content online, if you're the platform, that is, for individual users, especially the multitudinal data that is being shared on platforms like TikTok or Snule, etc., you may not be able to do this, but platforms can definitely do this, where they can create hashes, and if there is a modification of the code, they can immediately do some verification. Again, prevention may be the way forward for this. PCPNDT is another case I wanted to touch upon in the context of 69, 69A and B, and also Anuradha Bhasin's case. I think I will stop with this and open it out for questions. I know I did not realize it has become 12:30 already. Time does fly when we give our sessions on the digital domain. But to close this out, Anuradha Bhasin, again, the Kerala High Court had already decided with respect to internet being a fundamental right when a student protested taking away of her mobile phone. But when an entire state's internet was blocked, and India has the infamy of the maximum internet blockages, Anuradha Bhasin dealt with two aspects. Now, before the suspension rules came up in 2017, what was resorted to was Section 144 CRPC for curfews online, literally, right? And when that was contested by a law student in Gujarat High Court, in Gaurav Suresh Bhaiya's case, the Gujarat High Court refused to intervene because of the situation in law and order, etc. But when Anuradha Bhasin's case came up, also the Supreme Court stopped short. All it said was that the very name of the suspension rule says temporary. However, the rules does not really set a timeline for how long the blockage can be there. Even if the block had been done under 69A, there is a timeline of 6 months within which you have to stop it. You can't just keep it on forever. But under the temporary suspension rules, no such timeline is there. But what is it that the Supreme Court directs? It merely says that the review committee should keep reviewing it periodically. That by itself may not necessarily be a very effective check and balance. And this is something we'll have to review. So over to you, Prithvi. On this.
Thank you so much, ma'am. Indeed, we didn't realize how the time flew away, ma'am. Like 1.5 hours. It still seems very short.
Yeah.
Ma'am, I have received a lot of questions. I will definitely not be able to take up everything, but we have summarized a few questions, which is a general query for everyone. So, ma'am, if time permits, I can ask you like 3 to 4 questions, ma'am.
Please.
Quickly. Ma'am, first one, ma'am, how to identify that if I am a victim of cybercrime, and what is the do's and don'ts, especially for the youngsters who are living in the cyber world today?
It's very strange, I'm sorry I'm talking about cyber Saathi again, but this is precisely the purpose, intent and purpose behind it. I always tell people, so if Prithvi, you don't qualify for this because you are the millennial. You're what Prensky calls the digital native, okay? But a lot of my classmates and friends are there, like Aparna is there, etc. So let me take Aparna's example. So if Aparna buys herself a new mobile phone and she wants to use it, what will she do? She'll immediately reach out to her son and say, hey, you just get it sorted out and give it to me. Load this, load that. And then she may not know half the apps which he would load on that, right?
Yes.
And then it is very convenient when the digital native, the youngsters are dealing with the devices. Today, if I have to get on Zoom and if there is some problem with my computer, I would immediately reach out to the youngster in the house. So when you have divested your authority with respect to handling of the device, and then you go and tell them, hey, don't put so many photos on Facebook. Do you know what people can do with those photos? Don't do this. Don't befriend people you do not know. Just because your friends have befriended somebody, you should not be befriending them. Do you know what social engineering is? Someone can be pretending to be your age group. You're a school kid and you think you're, getting into a kind of online relationship or online friendship with somebody of your own age. And tomorrow you find it's a pedophile. It's an old person and a pedophile, right? You tell this to children or to even youngsters, or Prithvi, as I call you, young adults. All of you will just say, oh, you don't know anything, right?
Yes.
You don't even know the device. You don't know the domain. What are you talking about? The problems with it, right? So in these kind of situations, and this is what Cyber Saathi wants to make friends of, cyber friends of each one of you, to say that you have to know about what are the threats and vulnerabilities in the cyber world. Today, the demographic for this awareness is growing younger and younger. We used to say at least, for teenagers of 16 years or so should know. Then it became 14 years. And now we are saying we must have age appropriate, but definitely awareness content even for 8-year-olds or 6-year-olds, right? Because we are introducing them to this world faster than they want. So, nowadays, before the child is officially given its name in the registry, probably the social media account has been opened. An Instagram handle has been opened and photos are shared on that. And you want to see how many likes and whether it's become viral and whatnot. We forget that when something becomes viral, it brings with it also a lot of threats and vulnerabilities. Again, the same issue of prevention, protection, and then punishment comes in. Prepare them for what is there so that they can be peer mentors and tell others, look, like if you had a problem, you may probably go to a friend or to your sibling, right? And when you go and talk to them, they can then guide you initially and then see how you can take the help of an adult or an authority figure and take it forward. But if you have to suffer it alone, that is what then leads to more self-harm, and that is what leads to much larger consequences, of depression. And like some of the cases that I've dealt with, it's very scary. The levels of depression and, the physical disability that even a cyberbullying issue can cause is very scary. And the kind of demographic age groups are going down to something like 13 nowadays, So we have to understand as adults Today's children, youngsters, call them what they will, are very adventurous. You have armed them with devices, right? So once you've armed them with devices, you have to give them the manual on how to handle the devices. They are going to be adventurous. You tell them that tomorrow somebody can misuse your content as revenge porn. Tomorrow you may befriend someone, he will then take you somewhere, and then, like the Kolachi case can happen. That in itself may not stop them from still experimenting. But at least if you tell them, look, it can happen in the future, maybe at some stage, if they break up, they will ensure that the data is also deleted, right? And they will put in some safeguards or measures to protect themselves. So today we have to take this reality into account. We have to prepare youngsters. And I always say, just like how they can teach us about how to deal with devices, probably if we arm them, they can also guide us on how to handle cyber.
Thank you so much, ma'am. Ma'am, the next question is, gathering electronic evidences to prove it in a court of law is a big challenge in itself. Yeah. What is your take on it?
See, even one whole session is not enough to answer that question. But let me give you very simple answers. Whether you're dealing with cyber crime as a professional or electronic evidence, it may seem self-defeating, but let me tell you the first rule that I always tell people. Please delete in your mind the prefix. Delete cyber from cybercrime and delete electronic from evidence. Then as a practitioner, you don't have to be told how to deal with it, because you will immediately know that first principles apply. So I always start and finish my sessions on electronic evidence with this. You still have the same first principles that you have to apply, which is authenticity, integrity, and non-repudiation of documents. So when you know that you have to prove that this is authentic, you will do it by tracing from its origin to its final destination, the chain of custody. You will prove when and how the document came into being, who got it, or how they got it, who is producing it before the court, and how are they producing it before the court, and all the links between destination A to destination B. We would do it automatically for a paper document. It is absolutely the same with respect to an electronic document. What do we mean when we mean by integrity of a document? If I was relying on a paper document, that can also be fabricated, that can also be forged. So when we rely on an original of a document, we will prove the original. There may be something written on the original. So that is also an original document within the original, right? So we will have to explain why was this written, when was this written. A simple example I'll give you is when you are served with a notice, immediately you will note down in that document who received it, what was the date and time you received it. So tomorrow, if you have to prove that receipt, you will rely on the original document that was served on you with that original stamp of receipt, right? You will explain both. That is to show the integrity of the original, that nothing in the contents has been tampered with, and all the additions are also explained. It's the same with an electronic document also. The integrity of the electronic document is what is referred to in section 65B2 also. Many times people mistake the wording, the contents of the document, to mean the truth of the contents of the document. So once you prove an electronic record, and that is all it says, that it stands on par with an original, that's all. Beyond that, even in the original, you have to prove the contents. It is the same with electronic documents also, because otherwise I can send you an email claiming that you owe me 1 crore, and then I can do 65B perfectly because I have now read it inside out, and then you will owe me 1 crore, right? If the contents are deemed to have been proven. So what 65B says, and this is already decided in general laws by courts earlier, what it proves, the wording contents of a document does not mean the truth of the contents, it only means the integrity of the content, that it has not been tampered. Later on, once that document is taken and marked as an exhibit, you still have to lead evidence to prove the truth of what is set out there. Jaimin jewelry case from Bombay, also specifically refer to this. The three-judge bench in Arjun Pandit Rao is also dealing with that. So we come to the second stage of 65B. But remember, 65B is just the threshold. So once you do your chain of custody, once you prove authenticity and integrity, the third part of non-repudiation comes. So if I am claiming that your document is fabricated, the onus lies on me to show that the fabrication is there. You have proven to the first level through your 65B that there is no fabrication. Once I establish the onus, then the ball bounces back to your court. So when you remove the word electronic and you just substitute the electronic record with the paper record, and you set out all the steps you will follow in, and I always tell people, don't forget the basics: who, what, where, when, why, how. We used to write this down in literally this way when we would prepare for a trial. It is exactly the same procedure you have to follow when you're dealing with an electronic record.
Thank you so much, ma'am. I think you simplified it enough. It's just very simple. Just remove the prefixes.
Exactly.
That lies your answer. Thank you very much, ma'am. Ma'am, quickly, ma'am, in 5 minutes, we'll just sum up on this point. I mean, a lot of people have asked about the banning of porn content on the internet. How can all the government resolve together to take such a step? What are your views on that, ma'am?
Well, I have written a very controversial article about, why ban porn. And I started off by saying, I don't watch it, I don't care to watch it. But then if there are people, and if law says that watching it is not an offense, then what are we doing talking about banning of pornography? Two cases that have already been taken up by the Supreme Court with respect to this. The more recent one is the Vaswani case, and the earlier one was also there by Samhita Manch or something like that in 2010, where the court said as and when the government is faced with the situation where illegal content is found, then they will deal with the banning of the blocking of it. We are not talking here about a blanket ban, etc. So my take on this is this. One aspect of it is there is a huge market for this kind of content, and there was one article I came across when I was when I was writing this article about tackling women's freedoms and unfreedoms online. A lot of cases I wanted to discuss today. In fact, I've addressed it there. It's available online for people who want to read it. But I came across this article. Unfortunately, I've not been able to find it thereafter, which talked about the evolution of internet and how pornography has substantially driven it. And I am more concerned with criminal content online and banning or blocking of that. What I already talked about, like rape and gang rape videos, because here was a case where you had porn and then people wanted simulated violence, and that was what was given. And to me, when I look at cases like, uploading of rape and gang rape videos, actual offenses that are being committed, it's almost like the criminals are saying, why bother with simulated content? Look, I'm giving you the reality. Where are we leaving them with the level of morality or depravity, right? So I am really, really concerned with blocking or banning of content like that, and 100% zero tolerance towards child pornography. But when we are talking about general porn, it is for the government to decide whether it wants to bring in a law which is not going to be only making an offense of sale or dissemination, etc., but of even viewing. And only then we are going to see whether there is going to be a change in this circumstance. Because if you're going to have the demand, you're going to have the supply. And on this, if I can just take 1 second more to explain on the jurisdictional aspect. I had mentioned earlier, I will mention jurisdiction. Today in India, we have 3 different kinds of provisions which are going to apply for jurisdiction. One is under the IT Act, which gives extraterritorial jurisdiction under 75. And you have Section 4 IPC, which is mostly ignored, which also was amended to include for electronic records, etc. But CRPC remains the same with 179 and 188. Now, 179 makes the place where the consequences ensue also amenable to jurisdiction. But 188 says that sanction is needed in certain circumstances. Given the paucity of time, I'm just giving directions. I'm not going into the details. But here is the problem. And this is an interesting case, which is actually from the US, which can be applied for this situation for India. In the US, you actually have state laws which decide whether pornography is illegal or not. So state A says it is illegal, and state B, which is a neighboring state, says that it is fine and it is legal. Now the criminals sit in state B, therefore, and upload pornographic content online, and then just put a disclaimer saying if it is illegal in your jurisdiction, do not view it. Now the case was registered in state A where pornography is illegal. And the whole defense that was taken up was the offenses of uploading. And the place where it was uploaded was in a state where it is not illegal. And then that the disclaimer comes before people can access the content. And therefore, I am not amenable to this jurisdiction or an offense here. The courts held that the person was very much amenable to the jurisdiction because the content that is being offered is an offense within the jurisdiction where it was viewed. And even before the disclaimer, what this person had done to induce people to come and see the content was provided thumbnails. So the thumbnails, the courts held, were sufficient visibility for him to be held liable in jurisdiction A. Now, when we talk about India, this is going to be the same rule that will apply, because under IPC, you don't have a law with respect to viewing, right? But in IT Act, though it doesn't make viewing illegal, it says publishing and transmission of obscene content or sexually explicit content is illegal. So if you're going to take action based on that, viewing or demand or not, you can block it because the law says it is illegal, right? So this is that is going to be there, where the laws of a particular land make certain things an offense, you can find your enemy. And to close out the loop with respect to IPC, IT Act, etc., the problem is the IT Act 75 applies only for IT Act. IPC applies for IPC offenses, and CRPC is for everything. There it talks about a sanction. So I would say that harmonizing to ensure that all three stand on par is much needed.
Thank you so much, ma'am, for again an elaborate discussion on this also, which is an important content. Ma'am, I mean, I'm just getting so many questions, but then we are really running short of time. So I think we will not be able to take up all the questions.
If I may make a request, if you can convert the questions into a Word document, I will see if I can address it in some manner and share it with others.
Sure, ma'am. I can actually share with Aparna, ma'am, and thereafter we can do something about it. So
definitely, I'll try to address that.
Sure. Thank you so much, ma'am. Participant, I'm really sorry for not, due to paucity of time, I'm not able to take up a lot of questions. But this session, we will be uploading it on YouTube in our channel, which is Madras Tax Bar Chennai. So you can subscribe to that. We have already uploaded a lot of our webinars. We are slowly uploading everything, whatever we have conducted during this lockdown. So this webinar also is a very, very interesting one, and it is one of the longest webinars, and still people are very enthusiastically asking me questions. So I think you can definitely get access to that. So thank you very much, ma'am, once again. I now invite Aparna ma'am just to come, just to tell a few words and to end the session, ma'am. Aparna ma'am.
Yes. Nappinai, that was a wonderful session. Very interesting and very elaborate. And in fact, it's like an eye-opener for us because most of us do not know, we are not tech savvies at all. So, you know, it is really an eye-opener. You've delved through everything almost, you know, from cybercrime to jurisdiction to everything. Of course, people have a lot of questions because it's a very dynamic subject. And as you say, we will be uploading those questions to you. So you can answer them. And just one question which I would like to ask about the cyber Saathi. See, you say that it is going to be a friend for a person who, you know, seeks the help. Now, would you be maintaining confidentiality? That is very important. See, suppose, you know, somebody, a child wants to share its problem. That child doesn't want to share the problem with his or her parents. So would you be maintaining confidentiality? That is very important. That question, with that, I will close the...
Absolutely. Thank you for that question. And yes, it's very important. One of the things which should be inculcated with everybody. So I would take your question on two counts. One is, each one of you as a Cyber Saathi or a friend, each one of you should also understand that confidentiality is built into it. But when I'm talking about my website and being a first level help resource, the first thing that I ensured was twofold. One is we are still waiting for the personal data protection bill to come up, Aparna, before India. But what we already have is an indication of where it will lead. You already have a provision for child protection, personal data pertaining to children online. And the first thing it mandates is for parental consent and for very, very stringent encryption technology to be utilized for the data that you are retaining with respect to a child. Both of these I'm addressing. So no child can really use the space or post a query or even undergo the awareness program without parental consent. So I'm making it a two-factor authentication to ensure that parental consent and consequently parental guidance is there. One may say that it can be self-defeating, but it is something that is mandated given the situation. So this is the first thing which I've done. And yes, any data that is submitted is encrypted and will be retained only for the purpose and deleted then. Because the intent is not to collect data because there is nothing else we are going to do with the data. So therefore, that's the other purpose restriction, and all the 9 data principles which we keep advocating, I'm applying to.
So congratulations on your endeavor. You are taking such a proactive role in this. And thank you very much for accepting our invitation. I'm thanking you on behalf of the Madras Tax Bar. I know you're very busy. You're also busy in launching this website. But in spite of that, you've come here and you've addressed such a beautiful issue, which is so, which is the need of the hour, I would say. Thank you very much. And I also thank the honorable judges who are present here, who have attended this session, who participated. I also thank the Supreme Court Bar Association and the Bombay Bar Association. Thank you very much for encouraging us. And we also have a lot of webinars. Most of them have also been uploaded in the YouTube channel, as Prithvi just mentioned. And thank you very much. Thanks a lot.
Thank you for having me here. Thank you, Madras Tax Bar.
Thank you very much once again, ma'am.